circles. The rise of AI image generation tools like Midjourney is presenting unprecedented legal challenges.
Our established giants like Disney.
What's up, everyone? This is Olufemi Awoyale, your host in AI in business, ethics, and law. Over the past few weeks, we took a break to attend to physical conferences warning about AI risk and legal implication when it is not regulated. But we are back. So let's delve right into today's episode. In today's episode, we'll be looking at the case of Disney Studios and Universal Studios versus Midjourney. Now, what's the case about? Who are the parties and what's the implication for the intellectual property law as a whole and the innovation ecosystem as a whole? Let's delve right in. The plaintiffs are Disney and Universal Studios, own exclusive rights to copyright materials like Shrek, The Lion King, the Minions, The Simpsons, and a whole bunch of others. And we also have Midjourney, who happens to be an AI image generator registered in Delaware in the US. Disney and Universal Studios are suing Midjourney for infringement on their copyrighted materials. A backdrop to this is that the business model of Disney Studios, Universal Studios, and people like them is built on exclusive rights to certain characters and works. So infringing on these copyrights affects their business models. Also, in 2024, when they noticed this infringement, they sent a cease and desist letter to Midjourney, telling them that their platform is infringing on their copyrighted materials. But Midjourney snubbed Universal Studios and barely responded to Disney Studios. So now the matter has been filed in court. It was filed in a federal court in Los Angeles, a federal district court in Los Angeles. First, they argued that Midjourney directly copied their copyrighted materials and trained their model on it. Second, they argued that Midjourney's platform can produce an identical or very close to same product like theirs. In fact, they allege that all they need is certain vague prompts without mentioning the exact character that they want, and it's going to produce it. Take, for example, if you say some yellow 3D cartoon character with goggles and overall, then you have a minion. They also claim that Midjourney is a bottomless pit of plagiarism. They claim that their copyright infringement is calculated and willful because they had earlier sent them a cease and desist letter and they failed to do anything about it. In fact, they claim that Midjourney has a process for filtering out nudity content, violent content, and the likes. And implementing same for copyright infringement shouldn't be that hard if they wanted to. Those are the claims, or those were the claims of the plaintiffs. What if Midjourney wants to pull a fast one and say, it's not me, it is the user? In fact, that is what they are trying to do. If you look at the terms of service that they operated in with as at 2021-2022, it's different from the term of service they operate with right now. And the major differentiating factor in both terms of service is that the users are currently liable for any copyright infringement. So what this basically means is that when you use Midjourney and you infringed on somebody else's copyright, what the time of service is saying is that Midjourney is not responsible. You are.
Oh no!
The plaintiffs have a response to that. They are also claiming contributory infringement. What contributory infringement means is that you knew your platform was used to generate copyright infringed materials and you did nothing to stop it. They are also claiming vicarious infringement, which shows that they have the right to supervise and control their model. Yet they did nothing about the copyright infringement. They directly benefited from it because they made about $300 million in revenue in 2024. And subscribers who generated copyright content were part of their subscribers. So they are, in fact, they posted some of this copyright infringed material on their explore pages, encouraging users to download same. So definitely they must be vicariously liable. These are the claims of the plaintiffs. The plaintiff is praying for damages, statutory damages, profit that Midjourney has made on it, on the infringed materials, injunctive relief, attorney's fees, and jury trial. The defense, on the other hand, have not filed their own legal process. However, we can expect to see arguments like fair use. Fair use basically is saying that the AI was learning from it, was not producing exact replicas, or that Midjourney produces transformative products and not necessarily infringed copies. This argument might not fly because, as you will see in the links to the court documents provided below, you would see that the images were very identical. Also, we could see arguments around human AI authorship, which is that AI cannot be a human author or cannot be an author. At least, this aligns with the decision of the court in the Davos case that says that the AI cannot be an inventor. And basically, if AI cannot be the author, who owns, or what is the status of the originality of an AI generated work? Can an AI also be an infringer of copyrighted material? These are things that we need to look at, or these are things that might be argued. Also, they might argue that the feasibility of the claim by Universal Studios and Disney Studios that they should filter the content, well, they might argue that that's technically complex and might not be possible, in the sense that when you want to draw an image on Photoshop, imagine Photoshop has to go through a database that constitutes all of people's copyright information, and before it then produces an output for you to say whether this is infringing on someone's copyright or not. That's technically impossible in real time if you are opening to deliver a real-time product. So they might also argue that they are not targeting the same markets, which I believe might not fly, because sometimes, or most of the time, intellectual property infringements are usually strict liability. You might not necessarily have to prove some things. What would have to define what exactly copying means in the new age of artificial intelligence? Will training your model on certain data constitute copying? Those are questions for the court to answer. However, if the court mandates that, it constitutes copying, the implication is that we have a permissioned AI system. AI developers have to seek the consent of individuals or individual corporation before they get consent for training their model on their data. This no doubt will slow down innovation and also reduce the rate at which the US is going in terms of innovation, especially because they are competing with China. They are competing with China and they are barely staying ahead. So I think this is something to watch out for. I also think that the court ruling on what exactly the fair use is, what exactly will constitute derivative works would be very important, especially in this judgment. Well, we could argue that this entertainment giant Hollywood could have gone after the big guys such as OpenAI. Why are they going after Midjourney? Well, maybe they are a cheap target, and the implication is that if they are able to get the injunctions that they want against Midjourney, the implication is that all you have to do sometimes is just to present the precedent, and the AI community might begin to suffer. Also, if Midjourney is found liable for infringement, you know that AI companies will have to now go and be seeking the consent for data of from individual corporation. Also, the court gives a ruling that is too strict. It could stifle AI innovation, especially for small players, due to the increased legal and licensing fees. However, if they give a judgment too lenient, it could also devalue existing creative works, and impact the livelihood of artists. So this is a very delicate situation that we are currently. It's a very delicate situation, and we just have to test the waters, and the court has to help us in this situation. It's not an easy cause to determine. It's also not a slam dunk case. There are certain things to be proven or proved before such judgment will be given. The AI ecosystem and Hollywood are having a love-hate relationship, in the sense that the AI offers incredible possibilities for you to develop movies with artificial intelligence at low cost rates. On the other hand, it presents existential threats, to the very intellectual property that Hollywood community is built on. So yeah, it's a love-hate relationship. But let me know what you think. Is Midjourney a bottomless pit of plagiarism, or is this just an evolution of art? Don't forget to like, comment, and subscribe. See you in the next episode. Bye.